No objection.
Okay. Tire gauge?
No objection.
Yes, let him have, sir, have a seat.
Thank you.
And just take deep breaths. Do we need to call somebody for you?
No, I should be fine, ma'am. Just hyperventilating.
All right, do you need any water?
Yes.
Court is calling night mag number 758930, State of Texas versus Marlon Daniels. Can I have parties announced for the record for the state?
Jason Gary, hand on.
Defense?
George Sherman on behalf of the defendant.
And are you Marlon Daniels?
Yes, ma'am.
Welcome back to Ruling Hub, where justice speaks, and we listen closely. Today we're diving into a high-stakes case from Texas that starts with a simple motion for personal property, but quickly unravels layers of legal tension, emotional trauma, and a harrowing story of survival. At the center of it all is Marlon Daniels, a man seeking the return of everyday items, wallet, ID, gym bag. But what follows is a courtroom back and forth filled with hesitation, suspicion, and ultimately vulnerability. You're not going to want to miss what happens next.
Of some sort for getting around.
Let me go through the list and you just tell me what you have objections to, then I'll hear it. All right. His wallet.
Objection.
All right. And what is the state's objections to him receiving his wallet back?
Identification purposes, Your Honor, for him being in the vehicle.
All right. So is it possible for parties to make a copy of the items that are in the wallet, make a copy of his driver's license, make a copy of the VA documents, have the defendant and defense sign off to the fact that these are copies of the wallet, the driver's license, and the VA documents that were in the vehicle?
I'd be fine with that, Judge,
Yes, that's fine with the state.
All right.
as long as we can do it soon.
Well, that's something you all have to work out
Okay.
amongst each other. So the wallet, the driver's license, and the VA documents will be returned once the state has made copies of those. Mr. Daniels, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
You can lower your hand.
Thank you.
So you understand the wallet, the driver's license, and the VA documents will be returned to you once the state is able to make copies of those documents?
Yes, ma'am.
And you understand that your attorney has agreed that you will sign a document stating that the copies the state will make of the wallet, the driver's license, and the VA documents, you will sign a document stating that those documents, the originals, came from the vehicle, whatever part of the vehicle, and that you agree that they will have been found in that specific place.
Yes, ma'am.
All right. Personal documents.
This part gets legally interesting. The gym bag becomes a point of contention, not because of what's inside, but because of what might be. It shows how even mundane items like pencils or an air pump can be treated with suspicion. Why? Because when evidence is unclear, the court errs on the side of caution. Defense needs to be precise, or the item stays put. If you were the judge, would you return the bag based on that vague description?
You have to be very specific.
Okay.
What's in the gym bag?
Probably pencils, pen, an air pump.
All right. So with regards to the gym bag, the court is not going to agree to release that to you until people have had a chance to view what's in the gym bag.
Okay.
All right. Garage door opener. Any objections? Okay. Key card from work.
Maybe just a copy of it, Judge. I don't know if it has a photo ID or anything.
All right. So the key card from work.
It doesn't have photo ID, ma'am. It's just a regular,
All right. So what we'll do is the state will make a copy. Both defense and you will agree that that is a copy of the original that came from the vehicle. All right. So those will be released. Air pump.
So for basketball or some sort.
What is the air pump?
the air pump was basically for when I have flat tires, emergency purposes.
No objections to that.
Okay. Clothing.
I had two jackets, winter jackets, one hoodie, they're both hoodies. One's a zip up hoodie.
Winter jacket and hoodie. State, is that an item that you all can have somebody take photos of?
That's what I was going to suggest, Your Honor. Just we can take photos of those items.
All right. So they're going to take photos of those items. And again, counsel, and you will stipulate that those items were found in the vehicle?
No problem, ma'am.
Okay.
Sorry.
Documentation from glove box.
I believe it's an owner manual, might be a measuring tape, tire gauge, maybe registration and license, not license, but insurance paperwork. Can't think of anything else that might be in there.
All right, the owner manual.
We'd like that to stay with the vehicle.
All right, so the owner manual is going to stay with the vehicle because really, what can you do with an owner manual if you don't have the vehicle? With regards to the measuring tape,
No objection.
okay. Tire gauge,
No objection.
registration, insurance, and paperwork copies.
We'd like to at least keep that with the court, I'm sorry, with the vehicle, or at least make copies.
All right. So with that, there will be copies. Sir, are you okay?
Just breathing right now, ma'am.
Okay. Do you need to have a seat?
Right here, a startling human moment. Daniels begins to hyperventilate mid-hearing. It's a rare glimpse behind the stoic courtroom mask. Courtrooms are emotionally charged, and the pressure can break through even the strongest defense. This moment reminds us that while the law is rigid, the people inside these walls are fragile.
Fine, ma'am. Just hyperventilating.
All right. Do you need any water?
Yes, please.
I thought I had a bottle.
Quiet down, please, we're on record.
Could somebody see, do we have cups in the back to get him some water? All right. Thank you.
I get some food, sure.
And then state, do you have any?
Even the scooter becomes a battleground. The state insists on photos before release, reinforcing how everything, no matter how trivial, must be accounted for. Why does it matter? Because evidence missteps, even with a scooter, can derail entire cases. This ruling might seem small, but it's part of a bigger procedural puzzle the judge is carefully solving.
With regards to the wallet and the contents of the wallet, this and the driver's license, the VA documents, the state is going to take photos. Both defense and Mr. Daniels are going to stipulate that those are copies of the original, and you're going to stipulate to the location it was found in the vehicle. The air pump, the state has no objections. 2 jackets, the state will take photographs of those. Mr. Daniels in defense, you will stipulate that those are items that were found in the vehicle and the location of it. Documentation, the owner manual, that will be denied. Measuring tape, the tire gauge, state if you want to take photos of those and then give them.
Yes, Your
The registration insurance paperwork, the state will make copies of those. Both the defense and Mr. Daniels will stipulate that the copies are the originals and to the location where they were found. Scooter from the trunk of the vehicle, state will take photos, and both defense and Mr. Daniel will stipulate that those are photographs of the originals and where they were found. Is there anything else from either side?
Nothing from the state, Your Honor.
No, ma'am.
Anything else?
No.
Any other items?
If there is, I can't recall now.
All right. So, and counsel, if you all want to make arrangements for you and maybe the investigator or somebody to go view the vehicle, and if there's some.
Let's break it all down. The judge ruled that the wallet, VA documents, key card, jackets, and scooter can be returned, but only after the state photographs or copies everything. The gym bag and owner's manual, off limits for now. What we saw here is procedural caution and a judge balancing empathy with law. It's about maintaining legal integrity without denying dignity. In Daniels, he's cooperating but clearly burdened.
What's going on?
Hi, Judge. So a supplemental report was submitted to the court. Well, it wasn't submitted to the court. I held on to it to notify the court that Mr. Warrington did get evaluated for felony drug court. However, he was rejected because according to the documentation, he felt like he didn't need to be in felony drug court at the time. He's been in sobriety for quite some time at this point. He's been incarcerated since October of 2023. And he feels like possibly outpatient treatment would work for him. He was.
So are you saying that he wasn't accepted because he felt like he didn't need it?
It says, may I?
Yes. All right.
Can I finish?
Yes, you can.
So during his TAP evaluation, that was in April, it recommended him to be evaluated for DDRF. Well, when he went on to further evaluation for DDRF, they rejected him, saying he did not need the treatment, but he would benefit from outpatient treatment and being on the mixed caseload, the mental health caseload. The original conditions of probation indicate that you did want him to be referred to felony drug court. It also indicated that you would consider, or it was a term that he participated in dual diagnosis outpatient program. So I just wanted to make the court, remind the court of that.
Okay.
This is the moment that defines the judge's tone. You test positive once, I'm filing to revoke probation. That's a heavy hammer. She's laying down clear consequences. No gray area. This isn't just a warning, it's a courtroom promise. One misstep and the full weight of the justice system comes crashing down.
Going to end up happening. If you test positive one time, I'm telling them to file a motion to revoke. And I'm going to make a notation on here that you said you did not need felony drug court. So they're going to file a motion to revoke if you test positive. Do you understand?
Yes, ma'am.
Probation.
Your Honor, so would the original conditions already indicate dual diagnosis outpatient program as well as the mid caseload. So at this point, would you consider releasing him from Bexar County Jail to continue with the terms of probation?
Where is he going to be living?
I don't mind.
1033 Burlington.
No. Who are you living with?
Oh, that's right, Louise.
Who is she?
So, she's a very good friend that I met when I first moved to San Antonio. And she has a place. She said I can come stay with her. No, no, I have no contact with her whatsoever at all, period. None.
No. Here's the thing. She's the person you had contact when you first moved to San Antonio. Is this a person who knew about your drug issues?
No. So when I didn't take my issues at home. I never got high at home. When I did get high, I didn't get high at home. And when I did, get high, it was due to the fact of a situation had happened. And I felt like I didn't want to sleep anymore. Just like I had told him in my mental health, I felt like I didn't want to sleep anymore. That was the only way I knew that I didn't have to sleep. Because I woke.
Now we hit the heart of the case. Daniels opens up about finding his girlfriend murdered. The trauma is palpable. This isn't just a legal battle, it's psychological warfare within himself. For viewers, this is a turning point. The man on trial isn't just a name on a docket. He's a person drowning in grief, trying to hold on to sobriety as his past claws back. Does this change your perception of him? Should his trauma impact the judge's decision? Let us know in the comments.
Right next to you?
No, I was under the bridge. I was under the bridge with her. Cause she was home, but she couldn't go to my sister. My sister didn't like her. My sister thought she wasn't no good for me.
Okay.
So she can't come to the house, blah, blah, blah. I'm like, all right, well, I went to go see her one morning and I, fell asleep at her spot. Well, she left and came back and went in the back and I was woke up by a guy telling me I'm going to go back here and shoot this chick, but I didn't know she was back in the back. Heard the gunshot, went back to sleep, woke up, and when I went around, she was dead. This was in, I want to say the first week of September, right before I had gotten arrested. You know what I'm saying?
Mm-hmm.
So, and it was like, when I seen it, I'm like, man, no, this can't be. I'm like, why'd you do this? So I felt like, look, I can't go to sleep no more. I don't want to sleep. Like, the only person that I could talk to really at that point in time, you know what I'm saying, was gone. You know what I mean? And the dude that did it got away with it. So, like I said, I was clean. I know what it takes to stay clean. I have what it takes to stay clean.
All right. Probation, do you want him at felony drug court? Because they will address the mental health issues. They'll address the drug issues. I don't even know this person he's saying that he's going to live with. I don't think anybody knows the person he's going to live with.
Judge, another original condition of his was to participate in sober support meetings daily.
Mhm.
I don't know if it was for 90 days or 120 days.
120.
On the referral for felony drug court, another class was indicated that he could possibly benefit from. Other than that,
And that's the case of Marlon Daniels, a man at a crossroads between redemption and relapse. The court navigated a storm of personal trauma, legal objections, and procedural safeguards. The judge didn't just make rulings, she set boundaries, issued warnings, and offered a chance for recovery. Whether Daniels takes it, that remains to be seen. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. We've got real stories, real rulings, and real reactions, only here on Rolling Hub.
yes, Judge.
Is there anything else?
I'm gonna figure like what is, okay,
I'll explain.
okay.
All right.
All right.
Thank you. You're welcome.